Hello, brothers and sisters, and welcome to the virtual wrap session for our 2023 Tentative National Agreement. I appreciate you all joining us. As you all know by now, if you're watching this, we reached tentative agreement with the Postal Service a few weeks ago on a new collective bargaining agreement for letter carriers, and we are currently in the process of a ratification vote. In late October and early November, we held 4 different informational wrap sessions around the country where branch leaders from all over the country attended. We presented all the information, every single change that's included in this tentative agreement, and gave them the opportunity to ask questions. The purpose of this virtual wrap session is to give all of our members the opportunity to hear that same information, and we'll also answer questions that were submitted. So what we will do in this session is talk about, of course, the terms of the tentative agreement. We'll begin with the economic terms, and I will explain each of those in detail. We'll then get into the bargaining process. This is an agreement that took us about a year and a half of constant collective bargaining to reach. So I think it's very important for our members to understand what goes into that bargaining process and how decisions are made. We'll also then talk about what we call the work rule changes, things that are not necessarily economic in nature. In other words, they don't directly affect our pay and benefits, but are very important to the work that we do every single day. So we'll begin with the economic terms of the agreement. This is an agreement that, if ratified, it would go into effect retroactively to May of 2023. It will be a 42-month agreement. So this agreement would expire in November of 2026. Economically, the structure of our collective bargaining agreements that have served us very well for a long time have included a combination of general wage increases, cost of living adjustments, which we'll get into in a little more detail in a few minutes, and then also changes to our pay tables and pay structures that result in additional increases. So we'll take those one piece at a time. And the first piece is what's included in Article 9 of our agreement with general wage increases. In each year of this agreement in November, there would be a general wage increase of 1.3%. So 1.3% increase in November of 2023, November of 2024, and November of 2025. If ratified, those general increases in November of 2023 and November of 2024 would be paid retroactively in the form of Backpay, which we'll get into in a little more detail here in a few minutes. Next is a very important component of our economic package, not just in this tentative agreement, but historically, and that is our cost of living adjustments. We as a union have benefited tremendously, and letter carriers have benefited tremendously over the years from a cost of living adjustment formula that is as good or better than anyone else in the labor movement has. And we've certainly experienced that more so than maybe at any point in our history over the last few years, where we saw record inflation happen. But thankfully, this COLA clause that we've had for a number of years reacts to that inflation and increases our pay. In this agreement, the cost of living adjustment formula that we have is unchanged. It is the same formula that we had in the 2019 agreement, as well as several agreements prior to that. There would be 7 cost of living adjustments, the first of which would take place based on an index that we use to measure inflation called the Consumer Price Index. The first adjustment would be based on that index that was released in July of 2023. And then going forward, every July and January, when that Consumer Price Index is released, we would determine, based on the formula that we've had for a number of years, what that increase would be. There are a total of 7. 3 of them have already passed, so we know exactly what those 3 would be. The first COLA, which would be effective August 26th of 2023, would be $978 at top step. The second COLA, which would be effective March the 9th of 2024, would be $353. And the third COLA, effective September 7th of 2024 would be $978. So if you look at the three of those combined, that's $2,309 just in the first three COLAs. There would then be four more cost of living adjustments going forward, and we project what those will be using the same methodology we've used in the 2019 agreement and the 2016 agreement to project them. We use inflation forecasts from the Congressional Budget Office, which tend to be fairly conservative. If you go back and look in 2016 and 2019, what those CBO projections, how that translated into our COLA projections, the actual COLA increases exceeded those projections. So we feel pretty confident that this would be a minimum of the COLA increases. So what we project based on the Congressional Budget Office's inflation forecast over the next four would be for the COLA that would be effective in March of 2025, $620. The one that would be effective September of 2025, $604. And the COLA that would be effective in March of 26, $624. And then the COLA that would be effective in September of 2026, $561. All of those would be applicable to all of Table 1 and then Top Step in Table 2. Once again, these are projections. So as we move through and talk about some of the other economic terms and some of the other information I'll share with you in terms of what we project the wage increases would be over the course of the agreement, they do factor in these cost of living projections. And we'll talk a little bit more about COLA in a few minutes. So that's the baseline that we've had for a long time, the structure of general wage increases and cost of living adjustments. In addition to the general wage increases and our cost of living adjustments, we've also bargained some significant changes to our pay tables. These changes in the wage schedules will result in increases for a lot of our members, eventually for all of our members. Two of the goals that we had coming into this round of bargaining were to not only increase our starting pay significantly for career employees, which we did, and we'll get into the details of that in just a minute, but also to achieve an increase in top step pay, which benefits all letter carriers eventually. So there are several changes that'll take place. These changes would take place within 180 days of ratification, should this agreement be ratified. The first is the elimination of some early steps in Table 2. So effective within 180 days of ratification, steps AA, A, and B would be eliminated. Any letter carrier that was in steps AA, A, or B at that point in time would be moved up to step C. Those that are hired from that point going forward would begin at step C, which would include those that are CCAs that are converted to PTF through the automatic conversion MOU. Each of these increases would result in starting pay going up several $1,000s a year. It would be a significant increase in starting pay. It would also do something that hasn't happened since sometime in the mid-1970s, and that is reduce the time it takes for a letter carrier to get from our beginning pay to top step by at least 92 weeks. So that's a goal that we had as well, and we are certainly happy in this agreement to have been able to achieve that reduction in time to top step. Next is what would happen at top step, at step B. This would be applicable to both Table 1 and Table 2. In addition to the general wage increases and the COLAs that we talked about earlier, top step would increase by an additional $1,000 per year. So that is a one-time increase in addition to the general wage increases and COLAs that are included here. The next is an administrative change. We have, in this round of bargaining, really spent a lot of time moving toward a single pay table. I mentioned earlier that almost everyone in Table 1 is at top step. So those that are at top step in Table 1 at Step P would be administratively slotted into Step P in Table 2. This is purely an administrative action. It does not affect anyone's pay. It does not affect anyone's retirement contribution. It is simply an administrative move to move everyone into a single pay table. In addition to that, those that are not at Step P, when this goes into effect, when they reach Step P in Table 1, they would also be moved into Table 2. Next, the next change that also would go into effect within 180 days, it would be applicable to city care assistants. But before I get to that, let me talk about the other wage increases for CCAs. CCAs would receive the same general wage increases as career letter carriers, so 1.3% each November. In addition to that, because CCAs do not receive a cost of living adjustment, they would receive an additional 1% increase each November. So effectively, CCAs receive a 2.3% increase in each November of this agreement. In addition to that, within 180 days of ratification, on the same timeline as the three other items I mentioned earlier, CCA pay would be increased by 50 cents per hour. So CCA pay would go up an additional 50 cents per hour. Next is, I think, where we want to look into what does all this mean? Because pay increases, while structurally our CBAs have remained similar over the years, general wage increases, COLAs, changes to our wage tables, we have to look at what is the total economic benefit in terms of our wages. You know, when we get a paycheck, we don't look and typically say this dollar is, you know, this amount of increase is due to this and this amount of increase is due to that. So we thought it was important for informational reasons to share, you know, what we project the total benefit would be for the letter carriers, regardless of what your status is, what table you're in, or what step you were in. So we created a chart that I think gives a lot of insight here into the approach to bargaining and the process that we go through. You know, a very natural question to ask is, you're eliminating steps A, and B, and step P is getting an additional increase. What about all the people that are currently in steps C through O? And when we take a look at the benefit to everyone, regardless of which step they are at, we thought the fairest way to do this in this round of bargaining was to take those that make the least money, give them the biggest increase, and then have that incrementally shift as you move through our pay table. So if we start at our top step, which is step P, and this is true in both table 1 and table 2, we know what the 1.3% increase would be. I talked about a few minutes ago what the projection is for the cost of living adjustments, at least the 3 that we already know, and then the 4 that we can project. And we see an increase that would happen of about 11.5%, 11.49. As you begin to work back through table 2 and you take into account all the economic benefits, what you see is a gradual increase depending on what step someone is at. So for the purposes of the numbers that I'm about to give you, this is based on an assumption that a carrier starts at a certain step on day 1 of this agreement. So if on May 20th, 2023, a carrier's very first day in a particular step, what would the benefit be to them over the course of the agreement? This includes general increases, this includes cost of living adjustments, and this includes the changes in the wage schedules and the pay tables, and also the things that we were able to keep, such as step increases, all of which are bargained and negotiated in Article 9 of our agreement. A carrier that was at step P at the beginning of this agreement, May 20th, 2023, the salary was $75,299 a year. We project by the end of the agreement, which would be November 7th of 2026, that salary would increase to $83,954 a year. That's an increase of $8,655, an 11.49% increase. As we work backwards through table 2, a carrier that was at step O, and again, this is day 1 in step O on May 20th, 2023. the salary was $74,854 a year. We project by the end of the agreement that salary for that carrier would be $83,954 a year, an increase of $9,100 a year, a total increase of 12.16%. At step in, the starting salary was $72,796. That would increase to $83,954, an increase of $11,158, a total increase of 15.33%. At step in, at the beginning of the agreement, salary would have been $70,740. That increase would go to $83,954, an increase of $13,214, an 18.68% increase. So you can see as you go step by step, the total pay increase gradually goes up as we go work backwards through table 2. At step L, at the beginning of the agreement in May of 2023, the salary was $68,679. We project that the salary at the end of the agreement for that carrier would be $82,441. That is a total increase of $13,762 or 20.04%. At step K, at the beginning of the agreement, salary is $66,622. By the end of the agreement, it would be $80,175, a total increase of $13,553, a 20.34% increase. At step J, the salary was $64,562. It would increase to $77,912, an increase of $13,350, a 20.68% increase. Step I starts at $62,505, would increase to $75,641. This is an increase of $13,136, a 21.02% increase. Step H, beginning pay $60,448. By the end of the agreement, we projected it would be $73,374, a $12,926 increase per year, and 21.38%. At step G, the starting annual salary is $58,387. That would increase to $71,108, a $12,721 annual increase, a percentage increase of 21.79%. At step F, starting pay $56,327 per year. The ending pay that we project would be $68,843 per year, an increase of $12,516. That's 22.22% total increase. Those at step E at the beginning of the agreement, salary was $54,271. It would increase to $66,576. That is a total increase of $12,305, a 22.67% increase. Those that were at step D at the beginning of the agreement, annual salary of $52,211 would increase to $64,306, a $12,095 increase per year, or 23.17%. At step C, the salary at the beginning of the agreement was $50,153. That would increase to $62,037, an increase of $11,884, or 23.7%. At step B, starting pay at the beginning of the agreement annual is $48,094. It would increase to $59,773, an $11,679 increase, a total increase of 24.28%. Those at step A or at step AA, the salary at the beginning of the agreement, $46,038. It would increase to $57,504, This is a total increase of $11,466 or 24.91%. So once again, this chart and the numbers that I just read assumes that the carriers at each of those steps were at day one in that step was day one of this tentative agreement, May 20th, 2023, and it incorporates all of the pay increases that are bargained in this tentative agreement in Article 9, which includes general wage increases, cost of living adjustments, the changes to the wage schedule, the elimination of the early steps in Table 2, as well as the additional increase at top step, as well as step increases, which are all things that we bargain in Article 9 of the national agreement. There is also a way we created a method on the website for those of you that are listening or watching this, that you can go see exactly how this contract would benefit you. In the numbers I just described in the chart that you saw, and once again, if you're listening to this and you can't see the chart, check out the postal record. In November of this year, my president's message, I included this chart. Obviously, not everyone would be in the very first day of their waiting period for the next step at the beginning of the agreement. So some carriers would even get larger pay increases because they would achieve another step. So on the NALC website, if you just go to the front page at nalc.org, you will see right there on the top a link to a wage calculator that we created. And in this wage calculator, you just enter some information, what step you're at, when your last step increase was, and it will give you exact information on using the same baseline that we project with COLAs, but what the total economic benefit, including general increases, COLAs, step increases, and those changes to the wage schedule would be. So I encourage you to do that just to have that information about that's specific to you in terms of what that economic benefit would be. So a number of the provisions that we've talked about would be paid retroactively should this be ratified. I'm going to get into the specific pieces, but the first point that I think is really important is that back pay here is full back pay. There is no reduction of any kind. All of the general increases that would be paid retroactively, as well as the cost of living adjustments, are paid in full. They're rolled into our base annual salary. Those of you that have been around for a while remember probably throughout our history, we've had different pieces where COLAs were paid in lump sums and things like that. There is none of that. It's full back pay. What would be paid retroactively, we project that with the timeline of ratification that we will have the result of the ratification vote likely sometime in mid-January. Based on how long it has taken the Postal Service historically to implement new pay rates, not pay back pay, but just change current pay rates to update them. We project that would take place sometime in early March. So we have done some projections that we'll get to in just a minute based on the idea of implementing new pay rates in early March. When new pay rates are implemented, that ends the back pay period. So let's talk about would be included in this back pay. There are two general wage increases, one that was effective in November of 2023, one that was effective in November of 2024. Both of those would be paid retroactively. There are also three cost of living adjustments, one that would be effective in August of 2023, another effective in March of 2024, and another effective just a few months ago in September of 2024. Those total $2,309 a year at top step. So the calculation that would be done would go all the way back to August of 2023 for that first cost of living adjustment. For career employees, for CCAs, it would go back to their first adjustment, which would be effectively 2.3% in November of 2023. Every hour worked and paid leave, including overtime, is included in back pay. So to give an idea of how much back pay would be, we came up with some numbers just as a baseline to give an idea of how much that back pay would be. And let me first explain the basis for these numbers. So we created a chart or some information here for you just to give you, once again, simply a baseline. Like the numbers we discussed earlier on the total economic benefit, this assumes that the letter carrier at the indicated step is there day one in that waiting period at the beginning of the agreement. So May 20th, 2023. The back pay period, as I also just mentioned, goes back to August. And as pay increases are implemented and step increases happen, it changes back pay amounts. In order to provide these estimates, there's really only one way to do it, and that is based on 40 hours of work and paid leave a week. So the numbers I'm about to give you do not include any overtime work. Most letter carriers worked some overtime at least, and many worked a lot of overtime over the course of this back pay period. These numbers are based solely on 40 hours a week. And once again, for each step, it is if you were in that step on day one in that step on May 20th, 2023. So for a CCA, the baseline amount of back pay based on 40 hours a week would be $1,492. At step AA, if you were in step AA on May 20th, 2023, $2,359. At step A, $2,436. Step B, $2,542. Step C, $2,647. Step D, $2,752. Step E, $2,858. Step F, $2,963. Step G, $3,069. Step H, $3,174. Step I, $3,279. Step J, $3,385. Step K, $3,490. Step L, $3,596. Step M, $3,701. Step N, $3,805. Step O, $3,850. And step P, $3,856. And once again, this is assuming you were in that step on day one of that waiting period on May 20th, 2023, and only 40 hours, just straight 40 hours each week of a combination of work and paid leave during the back pay period. Now, of course, most letter carriers worked overtime. A lot of letter carriers worked penalty overtime. Some would get paid Sunday premium. All of the rates at overtime, penalty, Sunday premium are also increased by pay increases. So if you've worked overtime, and most of you have, your lump sum back pay is going to be more than those amounts I just mentioned. Those are provided really as nothing more than a baseline. As far as the timing of back pay, should the agreement be ratified, it does take some time to calculate back pay for a couple 100,000 people. We would anticipate that if the agreement is ratified, it would take a few months, so sometime probably in early summer or midsummer, back pay would be paid. For those that have worked some during the back pay period and since retired, if you worked at all during the back pay period, you will receive that back pay. Those that have retired in the last agreement, it was paid in the form of a paper check that was mailed to the office you worked in when you retire. All right, now let's talk about the process of bargaining, the economic piece. This agreement took a long time and about a year and a half to negotiate, which, if you've been around a while, that's not really unusual. Historically, we have taken a long time to reach agreements in most of our cases. So the modern era of our collective bargaining goes back to 1970, when all those brave letter carriers walked out on strike and to achieve collective bargaining rights. Prior to 1970, we only had very limited rights and we had no rights to bargain over our pay or our benefits. It was completely up to Congress at that time. But the result of that strike was legislation, the Postal Reorganization Act of 1970, that, among other things, gave us full collective bargaining rights and also laid out the process for our bargaining that has largely remained unchanged. So when we look at our bargaining history, what we would call the modern era goes back to 1970. That's since we've had full collective bargaining rights. And it's true that it has almost always taken us a long time to bargain a contract. And the question is, why does it take so long? And I think the way to answer it is not just simply that it's always taken a long time. It's important to understand why that's the case. And there's a number of reasons. Number one, our bargaining unit is the second largest single bargaining unit under one collective bargaining agreement in America, public or private. So this agreement affects more people than all but one other in this country. From the Postal Service's point of view, what they bargain with us is what they will pay in the future for what is their biggest expense, because we are the largest craft. And so it's a really grave responsibility on both sides of the bargaining table. And our union has a proud history of never settling for less than we could achieve in a particular round of bargaining based on the circumstances that are present at the time. And it's important, I think, at this point to get into a little bit about what happens if you can't reach an agreement, because that dictates the way we approach bargaining. Part of that 1970 postal reorganization law that outlined our process also gave us a resolution process if we were unable to reach an agreement. And that process is called interest arbitration. And interest arbitration is a process where a panel of three arbitrators, one chosen by the union, one chosen by management, and a neutral chair of that three-person panel that we jointly choose, makes a decision after hearings and evidence from both sides on what a particular dispute, they resolve disputes. So we have used this process in years past. And of course, as you bargain, you have to continually evaluate, can we achieve a better result by continuing to negotiate and hopefully reaching an agreement, or by continuing to interest arbitration? So we'll get to that here in just a minute, more about that thought process and interest arbitration. But back to the history and the reason it's taken so long is my predecessors as president, several of which I've had the pleasure of knowing and relying on and talking with about this process, have all, in my opinion, always made the right decisions as to, do we go forward to interest arbitration or do we continue to negotiate? And in our history, there have been points in time where we have used interest arbitration successfully. There have been points where we've done it, actually the majority of the time, and gotten mixed results. But in the agreements that we've reached over extended periods of time, I think it's true that we have always reached the best agreement we could possibly reach under those circumstances that were present at the time. And those circumstances involve a number of different factors. Of course, they involve what we feel like we need to achieve as a union. Our bargaining goals come from primarily resolutions that are submitted by branches and state associations, debated and voted on and adopted at our national conventions. They become our official bargaining positions. And in every round of bargaining, we set those goals. And we have extensive internal processes where we utilize the executive council. In this round of bargaining, each member of the executive council participated with a group in reviewing those based, on a particular topic, that help us develop what those goals are. But there are also circumstances surround us. We do not live in a bubble, and we have to evaluate ultimately for the purpose of what do we think interest arbitration would look like, what those circumstances are, and how do they affect not just what we're sitting at the table to negotiate, but how do they affect what would potentially happen in interest arbitration, the preparation of our case, anticipating what the Postal Service would present on a particular issue, and then what we think the outcome would be. So this is a process um, that we make decisions on an ongoing basis in a lot of ways of do we continue down the negotiation road, or do we move towards interest arbitration? And historically, our union has been really good at making the right decisions and using the process to achieve the best result that we could at any point in time. In this particular round of bargaining, we began with a number of goals. Of course, maintaining our cost of living, not giving up our standard of living when it comes to our cost of living increases, general wage increases, um, increasing starting pay, which we were able to do significantly, also increasing our ending pay, um, continuing our movement towards an all career workforce, which we have done through processes that have been ongoing for the last couple of years. As we progressed through negotiation and continued to bargain, we continued to make progress. Sometimes that progress was slow, but ultimately we got to a place where the Postal Service was willing to spend the amount of money it would take for us to achieve our goals. And then you have to, of course, weigh that against interest arbitration. Fortunately, we at NALC have a lot of experience in interest arbitration. That experience is officers, of course. I myself have been very heavily involved in 2 rounds of interest arbitration. But interest arbitration, our preparation of our case and presentation of that includes a lot of people. We bring in a number of professionals. We have a lot of professional staff, attorneys, of course, and we have people at NALC that are exceptionally experienced in interest arbitration. And I thought that it would be very beneficial, as we did at the 4 wrap sessions we had, for those of you that are tuned in here to hear from one of those who has been involved in a number, I believe 6 rounds of interest arbitration, to really explain the process and share with you a lot of the type of conversations that we've had over the course of this round of bargaining when making the decision of continuing to negotiate and ultimately reaching an agreement versus proceeding to interest arbitration. So Jim Sauber is the former chief of staff at NALC. He is an economist by trade and has done a lot more than just being an economist over the years for us, and was very involved in really led our preparation for interest arbitration in this round of bargaining. Jim also is very much an expert on a number of the topics that come up, such as the Postal Service's finances and the type of things that historically, they have presented. And I thought it would be very beneficial for you to hear from him, from his perspective about just interest arbitration in general, some about our history, just to give context surrounding this round of bargaining. So here is former NALC Chief of Staff, Jim Sauber.
Well, thank you, Brian. Thanks, President Ramaphosa, for that nice introduction. It's a pleasure to be back working at the NALC. I retired at the end of 2022. I've really enjoyed being able to come back and help out as a contractor. And so I've been serving as a consultant in this round of bargaining. It's something I've really always enjoyed in my years with the NALC. I've been basically involved with every round of bargaining since 1987. And I personally have worked on 6 different interest arbitrations, 2 when I was a research economist, twice when I was a research director, and twice as chief of staff. So it's a process I'm very familiar with. I'm not here today to weigh in on the decision that the members are going to make about this contract, but I am here just to provide a little historical context and to talk about what the environment was going into this round of bargaining, how interest arbitration actually works, and how the financial condition is an important issue when you're considering whether or not to go to interest arbitration, and how that financial condition can affect the risks and rewards of interest arbitration. So first, just to talk about where we are historically, the Postal Service has constantly had to reinvent itself to meet changing conditions over its history. We had a big, huge transition in 1970. We went from being a sort of taxpayer-subsidized cabinet agency to becoming a self-supporting corporation, or a government-owned corporation. And that's when, that was a really great time in our history, when we won collective bargaining rights, thanks to the men and women who went out on strike in 1970. But we're now in a major, huge transition once again in the 21st century. With the internet age, we've had a massive decline in letter mail, huge growth in e-commerce. And so it's really changing the nature of the Postal Service, and that certainly will have effect now and in the future as we do collective bargaining on behalf of our members. In 2009, marketing mail surpassed first-class mail as the largest volume of mail, and in 2016 and 17, package volume and package revenue passed first-class mail in terms of total revenue. So we're really in a quite different situation than we've been in the past. And so the Postal Service is trying to reinvent itself. It's got a major restructuring program trying to adjust to these huge changes that have happened over the last 20 years. We're moving from a letter mail business, a business dominated by letter mail, to one in which packages are going to carry a much more of the weight of the universal system. And so we're going to have a much more mixed and variable types of mail. We're now delivering ballots and prescription drugs and credit cards, and a lot less letter mail. And of course, the Delivering for America plan is really about how do we adjust our networks to handle this huge change in the mix of mail. Since the Great Recession in 2008 and 9, we've been in a period, it's this extended period, that when we teach our class at the Leadership Academy about bargaining, we refer to this as crisis era bargaining, because we've really been facing a financial crisis for pretty much nonstop since the Great Recession. When the global financial system collapsed, it really hit the Postal Service hard, and particularly in the industries that produce the most mail, real estate, finance, advertising. And so we lost 30% of our letter mail volume in the course of a very short couple of years. And, when we finally dragged ourselves out of it, we were suddenly confronted. Within 10 years, we had another giant recession caused by the COVID-19 pandemic, and we lost another 20% of our letter mail volume as mailers adjusted to the economic crisis that they faced. So the contracts that President Orlando negotiated, those last 3 contracts, were probably the most difficult in our history, our 54-year history of bargaining. President Renfro was a big part of those negotiations, and so is very familiar with the challenge of negotiating contracts when the Postal Service is struggling financially. Going into this round of bargaining, things have improved economically in the labor market. Certainly, in some ways, we had the best macroeconomic environment for labor negotiations than we've ever had. Lots of unions were getting really good agreements, and as President Renfro mentioned in his presentation, a lot of these huge gains that private companies are making now are sort of recovering for lost ground and major concessions that happened in the period after 2008, 2009. So I was hired in this round to help organize our interest arbitration case. That's something that's unique in our system of bargaining, since we don't have the right to strike. Postal Service does not have the right to lock us out. You have to prepare, even as you negotiate a contract, you have to prepare for interest arbitration, to put on the case that you would make in case you do reach an impasse. And throughout our history, about half of our contracts, we've had to go to interest arbitration, or at least start interest arbitration. And so that was my main duties over the last year and a half, was to work with Cohn, Weiss and Simon, which is the NALC's labor law firm in New York, to sort of build the economic case the NALC would make in interest arbitration. Just a little bit about the process. Interest arbitration, many of you are very familiar with rights arbitration, things that you do at the local and regional level, in which the issues put before an arbitrator are, what does the existing contract mean, and are the parties complying with it? Interest arbitration is different. It actually is a way of settling bargaining impasse to decide what's in the contract, what the actual provisions of the contract say. So it's a quite different process. It's to be clear that virtually any provision in the national agreement can be brought before an interest arbitration. It's up to the parties to make their proposals and decide what they want to change. Nothing's off limits. There's nothing that's guaranteed. Just because we've had it in the past doesn't mean we get to keep it in the future. Everything is up for grabs. As President Renfro mentioned, it's a tripartite system, meaning there's actually a panel of 3 arbitrators. Each the union and management get to name their advocate arbitrator, and between them they choose a neutral chairman. It's a semi-judicial process. You have court reporters and transcripts, and the cases are put on by teams of lawyers. Both sides hire law firms, outside law firms, to help them put together their cases. It often involves weeks of hearings spread out over many months to deal with the availability of witnesses and experts, but also the availability of the neutral arbitrator. Both sides get to call their witnesses to sponsor testimony and provide evidence and data in support of your case, and also to try to rebut the other side's case as best you can. There's actually 3 rounds to it. You put on your affirmative case for your demands in the contract. Then there's a rebuttal phase, and then finally a surrebuttal phase. So it's a very detailed, legalistic, judicial-like process. At the end of it, and sort of even at the beginning of it, legal briefs are filed. And then after all that work is done, basically what happens is the 3 arbitrators go into executive session. They go behind closed doors. And basically the bargaining resumes between the union and the management. And they're both trying to convince the neutral arbitrator to choose their proposals on all the various contract provisions. Once the neutral chairman makes his or her decision, he or she issues something called an award. It's the interest arbitration award. And basically, he just writes an award that identifies all the changes in the contract that he's going to award to the parties. That award is final and binding. You can't take it to court. You can't go to. There's nobody else to appeal it to, so it's a very high stakes process. And so that's a bit about how it works. Now, in every arbitration, I just want to make it clear, under the law, arbitrators on an arbitration panel are required to consider any issue or any bit of testimony or evidence that either party chooses to put before the arbitration panel. And so that means really anything goes. Any provision of the contract, every article of the contract, every MOU is subject to change if the parties want to pursue it. But there are certain issues that come up all the time that are just central to postal interest arbitration that really stems from provisions in the Postal Reorganization Act. Among these are things like pay comparability. There's a standard of private sector pay comparability built into the statute. That's the requirement for the Postal Service. They have to seek to pay what comparable levels of work in the private sector, that they match that pay and compensation. Of course, the trick is getting an agreement between the parties about who exactly are comparable workers. And it involves not just the work they do, but the kinds of employers they do, whether they have a union, are they national, are they local? There's a variety of areas where the Postal Service and the unions and the NALC have never quite totally agreed on on the definition of comparability. So that whole issue gets litigated before the arbitration panel But other things that are always in the case include things like the cost of living. That's a central focus of the NALC, is to protect the standard of living we've achieved through collective bargaining. And we look at what trends our real wages. We look at industry trends. We look at labor market trends, and basically both sides call witnesses on all of these issues. The key articles that always come up in the economic case include the structure of our bargaining unit. So, Article 7, in terms of the complements of part-time versus full-time workers, career versus non-career, and then the various levels of rights and protections each type of worker are entitled to. Obviously, Article 9 is the central area of battle, is, the number and scope of general increases, COLAs, lump sums versus general increases, step increases, the structure of the pay scale. All of that is determined in Article 9. Also, Article 21 on health benefits is a perennial issue that comes up in interest arbitration. At the moment, the Postal Service's contribution is set by the statute, the minimum payment. So it's not been a subject of debate in this particular round of bargaining. But historically, it's an area that Postal Service has really pursued. The average private sector worker now only gets 50% of their health premiums paid for by their employer. So our statutory level in the 70s is actually a pretty good level of protection. So in our preparation for this round of bargaining, I worked with our lawyers and the NALC staff to come up with a set of experts. We also rely heavily, both economic and non-economic issues, on the really excellent staff, city carrier staff employed by the NALC in Washington. And they really help put together what I think is the most essential part of any interest arbitration case, which is getting actual members of the NALC, active letter carriers, to come and testify on our behalf. And basically, we usually use these panels to reinforce whatever our experts, the professional economists and sociologists and healthcare experts, we bring in letter carriers to reinforce their messages and really ground our case in the working lives of our members. So that kind of gives you an idea of what we did and what we are ready to do if need be to pursue a labor contract through interest arbitration. Next, I just want to talk a bit about the financial circumstances that the Postal Service is facing right now and how that would affect the decision making both for President Renfro and the Executive Council about whether or not to pursue a contract in interest arbitration. So, as I mentioned earlier, I think we have a chart that we can show. It shows just the difficult period of time in the history of the Postal Service since 2012. This period of crisis bargaining after the Great Recession. The Postal Service has pretty much consistently lost billions and billions of dollars, and the losses have mounted, but were largely driven by the deep economic recessions, both in the financial meltdown in 2008 and 9, and then later with the pandemic in 2020. So over the last 3 years, the Postal Service has lost $24 billion between 2020 and 2023. That was sort of the backdrop of this round of bargaining. And this is the central part of the Postal Service's case. Whenever you do an interest arbitration, the biggest issue the Postal Service brings up every case is their ability to pay. They bring up the fact that under the law, they're required to make a profit and cover their own costs. Under the law, they get no taxpayer subsidies. And so the ability to pay is often the centerpiece of their case. In 2023, the Postal Service lost $6.5 billion. And then this year, just recently, they lost $9.5 billion. Over this time, their annual revenue has been pretty flat, $78 billion, despite really large increases in postage rates. And what's happened is mailers have responded to higher rates by reducing their volume. So these macroeconomic conditions are not, have really been strong headwinds for us in our attempts to negotiate a new contract. And this is the overwhelming challenge that we face if we go into interest arbitration. So let me just talk a little bit about interest arbitration as in terms of how you make a decision whether to go. It's important to know that it's not a risk-free option. It's both sides take huge risks by going to interest arbitration because the arbitrator, the neutral arbitrator, literally has the power to rewrite every provision in the contract. We've actually done fairly well in interest arbitration historically as a defensive mechanism. Usually in most cases, it's the Postal Service who refuses to make a deal, and we've been forced into interest arbitration. But there have been times, particularly in 1999, when the Postal Service was doing quite well and the automation process from delivery point sequences was in full swing, where we were the ones that wanted to get to interest arbitration. But I say, in the 6 arbitrations I've been involved in, the results are usually a mixed bag because arbitrators, they're inherently conservative. They don't like to disturb longstanding traditions or between the parties, but they try to help you get an agreement that the parties could in different circumstances reach on their own. And so what that usually means is there's a give and take. You win on some issues and you lose on others. So, for example, the very first arbitration we ever did was the Healy arbitration, and it was like a split decision. We get to keep our uncapped COLAs, but we lost some ground on layoff protection. In 1984, we got great general increases under the Kerr Award, but we also had to take a 17% cut in starting pay, which is obviously we didn't. The union didn't support. So that's the typical experience in arbitration. You usually take some losses as well as some wins. The one pure win we ever got was the 1999 arbitration, and that was in part because we structured it in a way that was very favorable to us. We had a last best offer arbitration, meaning we only had the arbitrator could only take our proposed contract or the Postal Service. He couldn't pick and choose. And we had such a strong case that year. Postal Service was growing fast. They had big profits. And the job of the carrier was obviously getting much, much harder due to the automation. So we had a really good case and we won that case as a result. And then I guess I just want to emphasize, it's particularly relevant to this round of bargaining. The 2 most unfavorable awards that we've ever gotten have been in the kind of conditions we're facing right now, in which the Postal Service is in deep financial stress. The first time in 1991, the Mittenthal Award, there was a recession in 1990, and then the Postal Service was hit by huge liabilities put on us by Congress, these budget reconciliation acts where they were shifting billions and billions of dollars in costs from the federal government for pensions and retiree health care to the Postal Service. And in that arbitration, that was the first time that an arbitrator basically made a decision to dramatically alter Article 7 and created the first group of non-career employees in the history of the Postal Service, the transitional employees, but there were other things like cashed out COLAs and lump sum payments. And that's when we took some big hits on the Postal Service's contributions to health benefits. Similarly, in 2013, in the teeth of the worst recession since the 1930s, again, under the DOS Award, that's when the DOS panel decided to create a very large, almost 20%, or 15 to 20% of the bargaining unit could be city carrier assistants. We had much lower starting pay. It's also when we first had the changes to proportional COLAs. So I give this history to you, and again, I'm not trying to sway your vote one way or the other. We are ready to go to arbitration if we need to, and we'll fight like hell to get the best contract possible. But I do think that you should know that the bottom line is that, that going to arbitration is not, it's not a one-way bet. And it should only be done with your eyes wide open that the possibilities are that you can win some things, but you can also lose them. So I think that's where I'll stop, and I hope this is helpful for all of you as you make this very important decision. And as I've said, whatever decision you make, it's going to be the right one, and we'll be ready to go to work on your behalf. Thank you.
That was former Chief of Staff Jim Sauber. Jim, thanks for that information. So you heard a lot from Jim about the process and our preparation for interest arbitration. So as we move through this negotiation process, there's a couple of things I want to point out in terms of decisions. The first is one that I mentioned briefly earlier, that on an ongoing basis, once we get past the initial 90 days of bargaining and the mediation period that happens immediately after expiration of a contract, you make sort of an ongoing decision about continuing to negotiate versus moving to interest arbitration. Of course, a decision that was made in this round of bargaining was to continue negotiations, because as long as we were making progress towards our economic goals, we thought that was in our best interest. And that's consistent with what our union has done for a long time. The last piece is when you get to a point where both parties have gone as far as they'll go. And, on the economic front, the Postal Service, eventually we get to a point where it's apparent that in terms of the cost to them of bargaining one of these agreements, that they are not going to be willing to go any further. And it's at that point that we decided to move towards finishing up a tentative agreement. I do think, for context, you heard Jim talk about some of the history of bargaining, and particularly the more recent history during the Postal Service's post-recession of 2008, 2009, 2010, beginning with the 2011 round of bargaining, some of the challenges that have been present. Part of this process was, as we looked at the things that we could achieve economically, of course, it's very natural to compare them to the previous agreements, of which I was very involved in negotiating in my time as Director of City Delivery first, and then for 6 years as Executive Vice President. So just for a few points of comparison, the 2016 and 2019 agreements both included general wage increases each year. The average general wage increase in this agreement is 1.3%, which is a slight increase over the general wage increase that we had on average each year of both the 2016 and the 2019 agreement. Our cost of living formula remains the same. That has served us very well in our history, and particularly over the last few years has served us very well in late 2021, 2022 in particular. We saw unprecedented increases as a result due to inflation that was going on. And then our wage schedule changes. And in the 2019 agreement, we added a new top step, Step P, that every single letter carrier that was at Step O and had served 46 weeks in Step O moved to the new Step P. And at that point in time, it was $444 more than the Step O rate at the time. So the increase that we are making to top step here at Step P of $1,000 is more than double what the increase was in the 2019 agreement. There was no such increase in the 2016 agreement. And then particularly at the beginning of our career pay schedule in Table 2, it has been, as I mentioned in the opening or early on, since the 1970s that we've reduced the time to top step and in this tentative agreement achieved a significant increase in starting career pay through the elimination of steps A, and B. And in both the 2016 and 2019 agreement, there was no such increase. So, really by any measure, the economic provisions of this tentative agreement represent improvements over what we saw in the 2016 and the 2019 agreement, and under very similar circumstances in terms of the issues that impact our bargaining environment, as well as ultimately what we would encounter in interest arbitration, as Jim explained. So, for all these reasons, the decision was made to finish the tentative agreement. That's not a fast process. There's a lot of a lot of details that have to be ironed out, and it took us several weeks to do that, including a lot of the work rule issues that I'm going to go through in detail here in just a few minutes. But just to kind of sum up the whole economic parts here, the economic package I think is straightforward. Once again, I would encourage everyone to, look at the entire economic package and not be drawn into focusing on one single piece, such as the general increase or anything like that. Last thing I want to mention economically, and then we'll move on to the work rules section, is very often there is talk and questions that are asked, and very well could be a question asked through in this virtual wrap session about step increases. And every round of bargaining, we bargain a number of economic issues in Article 9 of our agreement. We talked a lot so far about the structure, general increases, the cost of living adjustment formula that we use. In this agreement, we made some significant changes to our wage schedule. Another part there is step increases. And, the reason I think this question comes up is when the 2019 agreement expired on May 20th, 2023, and step increases continued. The reason for that is anytime we have in our history gotten to expiration of an agreement, we have agreed to continue the terms of that agreement. The same is true right now as we go through this ratification process. Our 2019 agreement is still in effect, including every single word and every term of Article 9. When you read Article 9, there are specific dates given for general increases. There are specific dates given for cost of living adjustments. All those have been fulfilled in the 2019 agreement. Step increases, however, continue, and we have agreed to continue that. So it is not a given that step increases continue. That's something that we have to negotiate. We then have to agree to continue them as we did when this contract expired in May. And this tentative agreement includes all of those Article 9 provisions, such as step increases. That's why they are included in many of the projections, all the projections that we have provided. Okay, in addition to the economic factors, there are a number of changes that we'll just categorize as work rule changes. And I will go through each one of them and give some level of detail. Some of them are very simple and straightforward. Some of them may require a little more explanation. And I'm sure there'll be some questions, and I'll answer those once we go through each of the changes. The first is uniforms. So let me begin with the uniform allowance changes or increases. In May of 2025, the uniform allowance would increase to $536. The additional first year allowance that's included in Article 26, Section 2B, would increase by $125. Then again, in May of 2026, the uniform allowance would increase to $549, and that first year additional allowance would increase to $128. Something that's new in this tentative agreement is the ability to carry over allowance from one year to the next. That's something that we've not had before. Currently, what happens when someone has an allowance and they reach their anniversary date, they lose whatever allowance they had on the books, so to speak. They will be able to carry that over. There is a limitation, however, that the balance at any one time cannot be greater than the cumulative amount of the current year uniform allowance and the previous year's uniform allowance. Uniforms are a big issue and something that we spend a significant amount of time in bargaining on. And honestly, the numbers I just gave you, those increases, were not what we spent most of our time on as it relates to uniforms. What we spent most of our time on was we've got to really reform and modify our entire uniform program. We have seen unprecedented increases in the prices of the items, and we've got a system currently that is broken. There is no cost control, and both us, obviously, for the purposes of our members being able to get the items that they need, and the Postal Service, because of the cost that will be passed on to them, we have a mutual interest in really changing this program. We have an existing MOU in our contract in the 2019 agreement. It is a city carrier uniform task force that allows us to do everything that we need to do. So while I gave you those increases in the allowance in 2025 and 2026, I can tell you the priority upon implementation of this agreement for us is going to be to work with them to modify this program altogether so that we are able to build in some cost control and ensure that our members are able to get the uniforms that they need. The next section is related to employee complement. I will just go through each of these changes fairly quickly. We've made a small change in Article 7, Section 1C. So currently the language in Article 7, Section 1C, Section 1C1 and 1C2 is language that places limitations on the number of city care assistants the Postal Service can employ. This dates back to the 2011 National Agreement and the DOS Award from 2013 that established these caps. The current language in Article 7, Section 1C1 limits them to 15% of the total number of full-time city cares in any one district. And in Article 7, Section 1C2, it provides them another 8,000 CCAs, but also limits them to 8% of the number of full-time cares employed in any one district. What's happened over the years is we have had a lot of agreements to increase complement, to convert non-career employees to career status. And some of those agreements have included creating part-time flexibles. And in some agreements, those PTFs have counted as full-time for the purposes of applying those caps. And other agreements, they have not. And essentially, it's gotten very complicated to track the number of full-time employees and the PTFs that count as full-time for the purposes of these caps and those that don't. So the change here is just a change from basing it on the number of full-time to the number of career employees. At the time this language was initially in our agreement back in 2013, the PTF classification was being phased out. That has very much been reversed since then. The Postal Service employs fewer CCAs than they have over the last 6, 7, 8 years, and that's not a result of them having less flexibility. It's just simply a result of we're employing a lot more career employees, PTF. So it's a very simple change there that really shouldn't directly affect anyone. Next is a small change to the MOU that does the automatic conversion after 24 months as a CCA. That MOU is entitled City Care Assistance Conversion to Career Status. There's a line in the MOU in the 2019 agreement that states that those conversions, those PTFs that are created as a result of that MOU would count as full-time for the purposes of the caps in Article 7, Section 1C. By us changing that language in Section 1C, that line is no longer necessary, so that line would be deleted. Next is the MOU called Full-Time Regular Opportunities City Letter Carrier Craft. This is an agreement that dates back that the very first version of this was created and agreed upon in November of 2013. The DOS award that created the City Care Assistant classification included language saying they would be converted to career status when the Postal Service needed career letter carriers. What it lacked was the mechanism for how that happens. So we initially negotiated this MOU to create that mechanism. It's evolved through multiple. First, it was just agreements we did outside of bargaining. Then it made its way into our collective bargaining agreement. And we have made a couple of modifications to this MOU. In no particular order, the first change has to do with the fact that this MOU was originally written at a time where PTFs were being phased out. As I mentioned a minute ago, that's not the case anymore. The number of PTFs we have just continues to grow, which is good. That's part of our pursuit of an all-career workforce. Um, we have situations sometimes where PTFs that back in the early days of these MOUs were given the opportunity to transfer ahead of everybody else to go full time. Part of that agreement was they were given retreat rights to return when a full time job came up in the installation they left, where they were a PTF. And we do occasionally encounter scenarios where those PTFs, there's another PTF that was senior to them at the time they left that has not yet been converted. This just makes clear that they cannot retreat until that PTF that was senior to them has already converted. Another piece that's also related to PTFs, after the ratification of the 2019 agreement, there was an MOU that we had to do that addressed the circumstance of someone transferring into an installation where PTFs were on the rolls. This is also a result of the fact that at the time this language was initially written, PTFs were being phased out. Now that we have thousands of PTFs around the country, when someone transfers in under this MOU, this language just makes clear that if there are PTFs there, they come in as a PTF. If there are no PTFs there, there's a full-time opportunity, they can come in as full-time. The last piece that I'll mention here that is something that we've used in a few select locations just in our continuous efforts to improve staffing and complement is a process to identify what we call letter carriers that are on the rolls and not available. So you go in, not every post office, but in a lot of places, you may have a carrier that's on the rolls there. They have an assignment, but they're not there for whatever reason. They could be out on long-term sick leave. They could be on military leave. They could be a 204B someplace. They could be a full-time union official. There's all sorts of, they could be injured. There's all sorts of possibilities. And basically what will happen, according to this language, is a review will be done. And when an individual has been out for 6 months or 13 pay periods, and they have no work hours, we'll create an additional full-time regular opportunity. It's an unassigned opportunity. We would fill it. It's just designed to increase the full-time complement. It does not impact in any way the letter carrier that's out. For whatever reason they're out. It is just simply as a result of the fact that they've been out, we create a full-time opportunity to grow that full-time complement. And this is something, once again, that we've done in a few locations around the country, and it's worked really well. I mentioned the MOU City Care Assistance conversion to full-time status, and that we have amended and deleted some language there that was no longer necessary because of Article 7, Section 1C. The next one is a modification to an MOU entitled Additional Resources Holiday Carrier Assistance. So since we've had CCAs in our craft, we've also had a category of employees that are for use during the holiday season. We've had this for a long, long time in different classifications of non-career employees. But holiday carrier assistance currently can be hired during the December period. We have done agreements over the last few years that allow the Postal Service to bring them on the rolls just for the purposes of training prior to that December period. The changes here, there are a couple of changes. Number one, it extends that December period an additional 2 weeks. In most years, that's going to be the week of Thanksgiving and then either the week before or the week after Thanksgiving. Those of you that really right now, peak season now starts in November. Peak season, used to be much more of a December thing, but, with online shopping and e-commerce and Black Friday and Cyber Monday and all that stuff, these resources are needed. So it extends that period by 2 weeks, and it allows the Postal Service to hire these folks and get them trained up on whatever they'll be doing. Typically, that'd be parcel delivery before that period starts where they can be employed. It's important to point out that this maintains protections for anyone that could be adversely affected by hiring them. CCAs that are on the rolls in installations where holiday care assistants are hired, they are entitled to all the straight time work prior to it being assigned to a holiday care assistant, and any overtime that needs to be worked has to be assigned to an ODL carrier prior to giving these holiday care assistants overtime. So it's just an extension of 2 weeks, frankly, during a period of time where we need the help, but maintains a protection against anybody that could be adversely affected. The next one that I'll mention related to complement is a test that we are going to conduct jointly um, with establishing care technician assignments that cover multiple installations. So we have, for the most part, in smaller installations, this applies to level 20 and below post offices. You may have 2, 3 routes, or you may have, say, 7 or 8 routes where you've got a care technician assignment, but you have one or more routes that are not covered by a care technician assignment. And what this test would entail is creating assignments that would cover multiple installations. It's beneficial because it provides, coverage every week for someone's non-scheduled day, but also is additional full-time work for us. So it'll be just a test phase to begin, and we look forward to working through that. Next is an MOU that was new in the 2019 agreement called Complement and Staffing. A lot of the work that we have done over the last few years related to our complement, improving our complement in so many places. We've done agreements we've converted hundreds of installations around the country to an all-career model where we hire PTFs and don't have non-career employees, have resulted from this agreement. The changes in the agreement in this tentative agreement, the change of this MOU, I should say, in this tentative agreement are just to recognize that success we've had, and also it's a commitment to continue that process, which has continued all through our this long period of collective bargaining. So we look forward to continuing that. Next is a very small change to a very important agreement. The MOU is entitled Article 7, 12, and 13, Crossing Craft and Office Size. We kind of refer to this casually as the bridge memo. It dates back a number of years to days when we bargained jointly with some of the other postal unions. And in a nutshell, this agreement says that among our craft, the mail handlers, and the APWU represented crafts, that the crossing craft provisions of Article 7, 12, and 13 in all of our agreements will remain the same as they were in the 1978 agreement, which is kind of important. And I'll talk a little bit more about this MOU later, but for the purposes of this change, is just simply changing an outdated term, man years, to work years. Next, let's talk about health insurance a little bit. And for the first time, I guess, since the 2001 agreement, there are no changes to health insurance coverage. There are no changes to the percentage of the premiums that the Post Service pays, percentage of the premiums that we pay. They remain exactly the same. That is true for career employees. That is true for CCAs as well. So the Post Service continues to pay the same, and we will continue to pay the same for our health insurance. Okay, next is Article 8 and overtime, and there are a couple of very significant changes here. These are changes that are consistent with our official bargaining positions and that we have tried to achieve in multiple rounds of bargaining, and we think will really be beneficial to our craft, and of course, keeping with the intent of Article 8, which is to protect those that don't want to work overtime while also providing opportunities for those that do and options for those that do want to work overtime. So the first change that I'll talk about has to do with maximum work hours. And before I get into the specifics of these changes, I think we need to talk a little bit about and understand where we are when it comes to maximum work hours. So we currently have maximum work hour limitations. For those that are on the overtime desired list, those are included in Article 8, Section 5G, 12 hours a day, 60 hours a week. There are, for those that are not on the ODL, there are limitations in other sections of Article 8. There are limitations in the Employee Labor Relations Manual. So there's a lot it's a little bit of a confusing issue depending on your classification. And these are work hour limitations that were supposed to be absolute. And it is something that we deal with a lot in the grievance procedure. Where typically where we have staffing difficulties for various reasons, where our members are forced to work beyond these maximum work hour limitations. What we pursue through the grievance procedure is, of course, make whole remedies, but ultimately to stop this problem of our members being forced to work is we want them to be protected from discipline. That whenever they reach their maximum work hours, they go home. And that's kind of what this bargain is centered around. So I'll go through it section by section. The first is a new section of Article 8, Section 2, and we've added a paragraph D that basically says that full-time carriers that are not on the ODL or work assignment list, so non-ODLs, their limitation is 11 and a half hours a day and 60 hours in a week. That's not a change in terms of what their limit is. The limits remain the same. But what this language says is they will not be worked over that. And when they reach those maximum work hours, they will terminate their tour and go home, and they will not be disciplined for doing so. A couple of very important points to make here. Point number one, this does not modify in any way any of the other relevant sections, Article 8, Section 4 or 5, related to the Postal Service's obligation to work ODLs and others before working non-ODLs. It is not an extension of Article 8, Section 5F. It does not change those limits that are placed. It only means that if non-ODLs reach 11 and a half in a day or 60 in a week, they can terminate their tour and go home, and the contract will read that they are protected from discipline. Now, one issue that we had to deal with, and I'll get to the ODLs, a similar protection in just a minute. But one issue that we had to really deal with is a pay rate here. Currently, when someone is forced to work beyond maximum work hours as a result of a national arbitration from a very respected arbitrator from years past named Carlton Snow, and this actually appears in our joint contract administration manual, there's a remedy of an additional 50% pay for those that work beyond maximum work hours. So there is a new provision added to Section 4, which covers various things, but in this context, we're talking about a pay rate where there is a new pay rate. Okay, as we'll talk about in just a minute, ODL carriers will have that protection against discipline, but have the ability to volunteer. But if any letter carrier works over 12 hours in a day or 60 hours in a week for any reason, it does not matter why, they will be paid 2.5 times pay. So this is a new pay rate. It is just like the overtime rate of time and a half. Penalty rate is double time. This is a new pay rate of double time and a half, 2.5 times pay. Okay, next let's talk about Article 8, Section 5, and talk about carriers that are on the ODL. So we have added language to Article 8, Section 5G specifically that covers ODL carriers in a similar way to what we talked about just a minute ago with non-ODLs. So ODLs are currently limited to 12 hours a day, 60 hours in a week. That limit remains. When those carriers reach those limitations, they may terminate the end of their tour and leave. They are not, and the Post Service cannot discipline them for that. That is crystal clear in the language of the tentative agreement. The other change here is that the Postal Service, if needed, may seek volunteers from the ODLs, and ODLs may volunteer, if they wish, to exceed 12 hours in a day or 60 hours in a week. If they do not volunteer, they simply clock out and go home, and they have protection from it. If they do volunteer, that new pay rate we just talked about would come into play. Once they exceeded 12 hours in a day or 60 hours in a week, then they would receive that additional 2.5 times pay. A couple of just points to make here. There are, for CCAs and PTF, there are no changes to their maximum work hour limitations or any application there. Things remain exactly the same, with the exception of the pay rate. The new pay rate for if they were to exceed for any reason 12 hours in a day or 60 hours in a week, CCAs and PTFs, just like all letter carriers, would receive 2.5 times the rate of pay. Next, just to clarify something, it does apply, these limitations apply daily and weekly. So just to give an example to illustrate that, if a carrier on the ODL, let's say, works 12 hours on Saturday, 12 hours on Monday, 12 hours on Tuesday, 12 hours on Wednesday, and 12 hours on Thursday, they have worked 60 hours. If they don't want to work on Friday, they cannot be forced to work and they cannot be disciplined for it, even if it's a regularly scheduled day. Let's simplify, create another scenario. They work 12 on Saturday, 12 on Monday, 12 on Tuesday, 12 on Wednesday, and then let's say they work 8 on Thursday. In that particular example, they will have worked 56 hours, which means if they come into work on that Friday, they'll reach 60 hours after working 4 hours, at which point, if they do not volunteer to exceed 60 in a week, they clock out and they go home. And the Post Service, because of guaranteed time, has an obligation to pay them for the rest of that day, and that pay would be at the 2.5 times rate. So the work hour limitations applies daily, but it also applies weekly. And the protection against discipline for terminating a tour comes into play whenever the daily or the weekly work hour limitations are reached. It doesn't matter when those limitations take place. The second major change to Article 8 has to do with the overtime desired list. And in discussions in bargaining and in convention resolutions, for us that our official bargaining positions at NALC conventions have adopted, we have tried to add additional options for letter carriers that want to be on the overtime desired list. So currently we have the work assignment list and we have the overtime desired list, which means you work overtime on any assignment, non-scheduled day, regularly scheduled day, up to 12 hours, or with a 10-hour preference, which we'll cover in a minute. The change here, we wanted to give options for those that may be willing to work overtime or desire to work overtime up to 12 hours on their regularly scheduled day on any assignment, but they don't want to work their non-scheduled day. And also for those that may not want to work past 8 hours on their regularly scheduled day, but they would be willing to work their non-scheduled day up to 8 hours. And that is what this agreement does. So what this agreement will do is when we get to the sign-up period, beginning 2 weeks before a quarter starts, currently you can sign the work assignment or you can sign the ODL. The options will be work assignment is unchanged. No change to the work assignment list at all. But you will then have two options. Option number one is a list that you will work overtime up to 12 hours on your regularly scheduled day on any assignment, but you will not work or not desire to work on your non-scheduled day. That's number one. Option two would be you don't want to work past 8 hours, but you would work your non-scheduled day. So you can sign one or the other, or you could sign both. And if you sign both, you are then on the equivalent of what is today's ODL. The only other change here is that the elimination of the 10-hour preference. So currently, when you sign the overtime desired list, you can indicate a preference to work 10 or 12 hours. It is simply a preference. It does not contractually limit someone to 10 hours. If the management has the obligation, under 85G to max out ODLs, they got to max out the 10-hour preference people to 12. And we actually tested this a few years ago around the country, the elimination of it with the establishment, and now with the establishment of these new lists and the additional options, there will no longer be a 10-hour preference. So this just provides multiple options, more options than we currently have, while maintaining the options that we currently have with what we know as the ODL today and the work assignment list. The one thing I'll mention that's a natural question, probably from shop stewards more than anybody else, is how on earth does this change the way we calculate and monitor and track and enforce the contractual provisions around equitable distribution of overtime? And the answer is actually very simple. And this would be reflected, should the agreement be ratified and explained in the JCAM, and that is they just simply have to, using existing equitability rules, make people equitable within the list that they're on. So you've got these two overtime desired lists. Whoever's on one list, all those people got to be made equitable. The people on the other list also have to be made equitable. So it's actually a pretty simple change. All right, moving on to some other important provisions. Layoff protection. We have layoff protection in our agreement for those that have 6 years as a career employee. It's been in place, a long time now. Thankfully, it's something that we have never really had to invoke. We certainly don't anticipate over the course of this agreement having to invoke the layoff protection, but the layoff protection is continued. This is one of those things, along with the next topic I'll mention, that is not often talked about, among our members. It's not something, as I go around the country and meet with our members, that we talk about a lot, but it is a topic of collective bargaining. So layoff protection continues, as well as our protections against subcontracting. Those of you that were around back in the mid 2000s remember this was quite a battle in the 2006 round of negotiations, and in that round of bargaining, we achieved some significant protections against subcontracting that are mostly in Article 32 of our agreement, but also mostly in the form of MOUs. And those protections continue. So they've served us very well, and we're happy to continue them. Okay, next is a modification to a task force called the City Delivery and Workplace Improvement Task Force. This is a kind of big umbrella of different topics and therefore different work groups that we do jointly with the Postal Service at headquarters. This task force covers a lot of different topics. There's kind of a high level oversight, and then we assign what we call subcommittees, which are officers and staff from NALC that work with managers from the Postal Service headquarters on different topics. And the changes that we've made here are really, more than anything else, just to align with the way that we actually structured those subcommittees in practice in the 2019 agreement. But a lot of good things have come from this. We've had a lot of productive things related to route adjustments and complement and staffing, and what we do with onboarding employees and mentoring and retaining them, which we'll talk about here in just a minute. So this task force will continue. We are, should this agreement be ratified, excited to get started with it and address all the topics that are included there. Next is a new MOU called the New Employee Experience Retention and Mentoring Program. This was a result of that City Delivery and Workplace Improvement Task Force. We've tested this all over the country. It's in currently it's in a test phase still in almost 1,000 post offices around the country. But the idea was for us to structure the work and the experience for newly hired employees. Some cases that's CCA, some cases that's PTFs, and just give them the best opportunity we could to learn the job and to succeed. This began as just a retention pilot program. It puts in, as you see the MOU, it's very detailed. It puts in work hour limitations during their first few weeks of on the job. It also includes certain items that have to be provided to them, and just structures the experience, the feedback that they get. We also had a separate mentoring pilot at least early on. I guess back in 2020, 2021, late 2021. And mentoring was just identifying, an experienced carrier that could be kind of a point of contact for a new employee and help them. We then merged those two together, and that's what this agreement represents. So it's been very successful in places that we've been able to hire employees, and we're definitely excited about the possibility of implementing this nationally just to improve staffing and improve the experience for employees that we hire and NALC members. Okay, next is an existing MOU that in the tentative agreement really doesn't look anything like the existing MOU. We've changed it so much. The joint workplace and improvement process. This has been around for a few years now. JWIP is what we call it for short, and it was brand new, and it was mostly headquarters driven. And as we had varying levels of success with it, we learned a lot from it, and we have significantly modified and added lots of structure that'll allow us, we think, to have greater reach. And this is just an additional avenue, um, going above and going beyond what we do best, and that's enforcing our agreement through the grievance procedure to address the problems we have that contribute to poor work environment. So the structure that we put in place, potentially with this agreement, we think is going to allow us to really reach into more locations and the places we have that are toxic to work because of all sorts of things. But usually at the core of it is contract compliance and people's behavior. Give us the opportunity to address those, beyond all the things that the methods that we already use. Um, Local implementation. So our LMOUs, branches out there I know are hard at work in preparation for local implementation. There are no substantive changes to the process of negotiating locally, with one exception, and that is what the period would be. So the local implementation period, should this agreement be ratified, would be April the 3rd, 2025 through May the 2nd, 2025. Okay, let's talk. There's a couple of agreements related to route adjustment that are important for us to cover. Um, the first is an agreement that there's not really any substantive change to, but I think it's worth mentioning. The MOU on alternate route evaluation and adjustment process. This is an agreement that we've had going back to the early 2000s, and we've had 6 separate joint route adjustment processes, back to IRAP, MyRAP, JRAP, JRAP2, CDRAP, and most recently TIRAP. And each of these processes has been a result of what this MOU established. So this agreement continues, and we intend to continue to utilize it to try to reach agreement with the Postal Service on joint route adjustment processes that are fair. Of course, coming off our most recent joint process, there's a lot of pieces of it that work very well, and there's a lot of pieces of it that in any future joint process need to be modified based on the experience that we had. So, the discussions that we will have would start there, just as they have in the past with the most recent process, but while also, learning, knowing what we learned and trying our best to, come to agreement on a process that addresses those concerns and continues to move us forward. Because ultimately, NELC having a seat at the table in a fair joint route adjustment process is the best way to adjust routes. And we will continue, towards negotiating to do just that. The next MOU is a new MOU, and it's related to joint route adjustment processes, and it has to do with fixed office time. And fixed office time is an issue that we, through a lot of our joint processes here at headquarters, at least in the now 13 years that I've been here, we have been very heavily engaged with them on trying to find a better way to evaluate fixed office time. Fixed office time is office time that we spend that does not include casing mail and pulling down mail. So it includes things like dealing with accountables and dealing with checking our vehicles and personal needs time in the office and going withdrawing our parcels and whatever other things we do in the office besides casing and pulling down mail. And the system that we have and that we've used in each of our previous 6 joint processes is almost exactly like the system that's used in Chapter 2 of the M39, where the Post Service does unilateral route adjustment processes. And what this agreement does is recognizes that in future joint route adjustment processes, we should improve that system of evaluating it. So the way office time is structured for routes, when we evaluate them, we come up with a standard, 18 letters, 8 flats per minute based on the caseable volume, but we also have to have a fixed office time piece that is considered in that evaluation. And in Chapter 2 of the M39, that fixed office time has minimum time values for each line item or different activities. And those line items are used as minimums to create this fixed office time. What we currently, in a joint process, or at least in our previous ones, do not have is a way to efficiently evaluate what that fixed office time is for every route, because it needs to be as accurate as it possibly can be. Because if it is inflated too much or it's too little, it causes problems in both directions. And ultimately, in any joint process, what we're trying to do is evaluate a route based on the time it takes the carrier to do it. So what this does is first recognizes we need to find a new way to do it. We're going to do it. And what we're going to do is find a way to evaluate the fixed office time that each route, that carrier on that route actually uses. And then, because line items have been such an important piece of this, that at least historically, what we have agreed is that when we make this change, we've set bare minimums for each of these line items. And it's just a handful of line items. We've changed some of the ways that we would record mail. So I'm going to go through the line items that are changed and really explain why. The first one is, or actually the first 2 are have to do with ways that we would record certain activities. So lines 8 through 13, which currently include things like handling changes of address and markup mail and stuff like that. That work has changed so much over the years because of the volume that we handle in the office in the morning has gone down dramatically. So rather than use line 8 through 13, we are not going to use those lines anymore. We would still record the time it takes, but we're going to record that time on line 21, which is office work that's recurring, that's not covered on another line item. The next is withdrawal of mail, which is line 15. Withdrawal of mail is very inconsistent in terms of the way it's recorded, especially as we've established SNDCs. In some locations, carriers have to, really take a long time and walk a long way to get their parcels. A lot of times that's recorded under line 15. So any time that previously was recorded under line 15, the time obviously still there. It will still be recorded. We just won't use line 15. We'll also record it under line 21. Because ultimately where we want to go here is to simplify this process. The things we do are either recurring or they're not recurring. And what is recurring that we do, on a recurring basis should be included in the evaluation of our route. The other changes from what has been the minimums, the most significant one is line 14, accountables. In Chapter 2, that minimum has been 6 minutes in the office. Based on a lot of the studies that we've done and Post Service has done, there is a significant change to what we do with accountable mail in the office. Most letter carriers know that certified mail, which is by far the highest volume accountable piece that we get. Most of the time we spend handling those is on the street now, as opposed to in the office. So that's been a pretty significant shift. But in any joint route adjustment process going forward, the minimum would be 2 minutes. So no matter how much time somebody spends on accountable mail, and for some people that might be nothing more than getting a key, that value will not go below 2 minutes. Line 19, which is vehicle inspection. Vehicle inspection is unchanged. It will not go below 3 minutes. Line 20, which is personal needs, that is the time that we spend on the locker room, restroom, that type stuff. Currently, the minimum of 5 minutes. It will not go below 5 minutes. That would remain the same. And then line 21, the current minimum for line 21 is 9 minutes. That would be increased in a joint process to a minimum of 10 minutes. So the terms of this MOU only apply to these line items, only apply in a future joint process. And just as importantly in this MOU is the commitment and what that joint process would allow us to do. And that is to evaluate the time on every route, what the carrier actually takes, and what should be fair for them on that route in the calculation of fixed office time to apply to their standard, for evaluation purposes only. This is only for evaluation in a joint route adjustment process. This is not for daily workload measurement or anything like that. It's only in the event we're able to come to agreement on a joint process. Okay. A few other things I'll go through fairly quickly. Article 2, Section 1, we have made some changes to include pregnancy as a protected class. And then in the second paragraph there, we have modified the term handicapped employees and replaced it with individuals with disabilities. Also, Article 8, Section 3, this is a really good change, that PTFs and CCAs will be guaranteed at least 1 day off per service week. A few changes related to leave in Article 10, the monetization of annual leaves, a new MOU. This would allow our members that carry over the maximum number of leave hours to sell back some annual leave. There is a requirement that they can not have exceeded 75 hours of sick leave usage in the previous year. Questions that often come up about that are, is there any impact of FMLA? And the answer is no. It doesn't matter why the sick leave was used. It's just simply a threshold. They have to use less than 75 hours of sick leave, and then you can cash in up to 40 hours of annual leave. CCA advanced annual leave. So upon completing a 360-day term and then being reappointed, CCAs will be advanced 40 hours of annual leave, which is a big step forward for us. That's a good thing for those CCAs that come back after completing a term and may want to take some time off. Similarly, PTFs, once upon hiring, would also be advanced that same amount of annual leave if they are CCAs converted to PTFs or PTFs hired in the middle of the leave year. Then upon becoming a PTF in whatever fashion, they would be given a prorated amount of the 40 hours for the rest of that leave year. The bereavement leave MOU, which gives us the ability to take annual leave or sick leave or leave without pay for bereavement purposes for certain family members. We've expanded the definition of family members to include grandchildren. So, in the unfortunate loss of grandchildren, that would be eligible. You'd be eligible for bereavement leave now. A new MOU on time limitations about bone marrow, stem cell, blood platelet, or organ donations for those that participate there. This is provided for in the ILM to take the leave, and what we did is created some their limitations, but they're consistent with what's the typical amount of time someone would be absent. So it clarifies and clears up any potential disputes over the amount of time someone would use. Article 11, holidays, couple of changes. Officially, Juneteenth becomes our 11th federal holiday. We have observed that the last few years, but that will now be in our collective bargaining agreement. And as a result, the way we calculate PTF hourly rates changes. So currently, we have, and whatever step a carrier is at, if to calculate a full-time carrier's hourly rate, you take their annual salary and divide it by 2,080. PTFs are not paid holiday leave on the holiday, but they are compensated for the holidays because to determine their hourly rate, you subtract 80 hours currently, the 80 hours for the 10 holidays we had prior to Juneteenth, and divide the annual rate by 2,000 to equal their hourly rate. With the addition of another federal holiday, that means you have to subtract 88 hours because we now have 11 federal holidays. So PTF hourly rates are now determined by taking the annual salary and dividing it by 1,992 instead of 2,000. Some changes in Article 12. Throughout Article 12, there's a lot of sections that are not and haven't been for some time applicable to our craft. You will see that, if you look in the JCAM, you'll see language often that says this is not applicable to the letter carrier craft. We have agreed to remove all of those sections of Article 12 that are not applicable to our craft. That's just something we've talked about in years past. There was hesitancy to do so for reasons that are really historical in nature. I mentioned the bridge memo earlier, the MOU, Article 7, 12, and 13, crossing crafts, that we are party to, as well as the mail handlers in the APWU. But, over the last several years, with us developing our conversion to career process and transfer process, and the other unions following that and having their own processes, we're in a place where we're pretty comfortable with the application of the limitations in that bridge memo to go ahead and clear up Article 12 by removing these sections. Another change in Article 12 has to do with those that leave our craft and come back that leave our craft to go to a non-bargaining position. So now when someone leaves our craft, typically they're going to go be a manager full-time, but it's not just related, not only applicable to going to be a manager. When they leave and come back, if they come back within 2 years, their seniority, they retain their seniority except for the time they were away. If they come back after 2 years, they have to start a new period of seniority. The change here is to change that 2 years from 1 year. So when someone takes a non-bargaining position outside of our craft and they return, if they return after 1 year, they will have to start a brand new period of seniority. And then finally, a section, Article 12, Section 5C8, is about accessing part-time flexible employees. We have language in our JCAM that makes clear that this language talks about a quota of PTFs, which is something from years ago, doesn't exist anymore. Our JCAM makes clear that complement is covered by Article 7, Section 3, not by this quota. So we agreed to delete this entire section about accessing PTS because in reality, in the absence of a quota, there's no reason really to ever have to access a part-time flexible letter care. Article 14 to do with safety, a pretty significant change here. We have, for a number of contracts, we've tested the a concept called district safety committees in a pilot form, where around the country we've had joint committees at the district level that addressed a lot of different safety issues. Those in recent years have we kind of struggled with them, to be honest, through some restructure with the Postal Service and the way they change their district structure. But that will no longer be a pilot. They will be everywhere. We will insert this. It's going into Article 14, Section 3. So we will have district safety committees in every district, which is a really positive thing for us. It's another avenue to address any issues that are related to safety. An MOU also related to safety, a new MOU on air-conditioned vehicles. Post Service is in the midst of purchasing a lot of vehicles, and this just says they are going to put air conditioning or make every effort to put air conditioning in all the vehicles. If they intend to purchase a vehicle without air conditioning, they have to talk to us about it first at the national level. It's highly unlikely that would happen. This is just a protection. And it also makes clear and obligates the Postal Service to keep up with maintenance procedures to maintain the air conditioning in vehicles in good working order. Okay, next in Article 15, a grievance procedure. The changes here are mostly related to Step B and the things that are administered through our National Business Agents offices and from headquarters. And we've gotten rid of a couple MOUs and combined them into a single MOU, and also put a little more structure around the task forces that we have in place. The MOU DRP testing, we put a time frame where we would get together and talk with the Postal Service about. A new MOU related to Article 15 that will certainly be of interest to our stewards is a commitment and some guidelines for testing an electronic grievance system. So this is, I think, a great opportunity for us. It starts with the way we request information and receive information requests to the way, we move grievances through a process and, could really improve the efficiency of our process and, give more visibility in terms of time frames and timestamps and things like that. So this, of course, it will be new. It'll be something that we'll have to do probably a significant amount of testing. But I think it's very promising, at least in concept. One kind of just point to make: this test would apply to the portions of the grievance procedure that we do with the Postal Service and moving grievances through the procedure. What it would not apply to is what we do internally. So, for example, if in your branch a shop steward files a grievance at informal step A, gets documentation, they initiate a grievance, talk to the supervisor, and then the process is to send it to the branch hall or to the formal A rep. That sort of internal union movement of the grievance more than likely is not going to be a part of this. This is just about, once we get it formal A, and for example, exchanging documents or appeals to formal A could be a part of it. Moving a case to step B, could be a part of it that we do jointly. But it would not apply to sort of our internal. We would develop stuff like that unilaterally, which is definitely on our radar. Okay, Article 16, Section 7, the emergency procedure, emergency placements or suspensions. The only change here is that individuals that are placed on emergency suspensions during that time that they are out in a non-pay status, they can use annual leave if they wish to have some income. It's totally at their discretion. This will not impact in any way grievances or make whole remedies. It just is intended to allow them to have some immediate income. Obviously, if someone used their annual leave here, a grievance was filed, we were successful in a make whole remedy, having their leave balance restored would be perfectly appropriate to request. So it's only intended to give them the ability to have some income in the interim. In Article 17, a couple of changes. One places a requirement to have labor management meetings at least twice per year. Previously, there was, labor management meetings existed, but there was no frequency that was required. So, at minimum, they have to happen twice per year. And then Article 17, Section 7 has been modified significantly to change the way that we handle dues with the Postal Service, union dues. Currently, what happens is when someone joins the union, there's a process. It goes through the Post Service Human Resources Shared Services that, a piece of it we don't have control over. And those of you that are out there that are involved in the administrative side of your branch or, dealing with membership rosters and dues and stuff like that, that sometimes delays happen. But basically, the union, we will take over the responsibility for dues processing and just simply tell the Postal Service through an electronic file how much money to hold out, from each member of our union. They would then submit the money to us, and then we would do just as we do now and distribute that money to the branches and state associations. In addition to that, they are going to process allotments that we provide. So, rather than us having to use up one of your current payroll allotments to contribute to anything. For example, we have our Disaster Relief Foundation, our Letter Care Political Fund. You would authorize that through the union, and then we would tell the Postal Service once again through a secure electronic file. All right, Article 23. This is about our rights as union officials to enter postal installations to conduct official business. It just makes clear those that are retired or full-time union officials that are serving in a role, they will be granted a postal ID just to make it a little easier when it comes to their access. We've talked about a lot of MOUs already, but there are others in our contract. Most of them will continue without substantive change. Some of them have minor changes, such as date changes that don't affect the actual meaning or application of them. But there are 5 that will not continue. And I want to just so we're discussing every single modification here, cover what those are. FSS implementation, FSS work methods, those 2 MOUs would be deleted from our agreement. They would be deleted because FSS is gone. Post Service has discontinued it, and there is no intention of bringing it back. So there's no need to have those MOUs in our agreement anymore. The District Safety Committee's pilot program, that MOU is being deleted because, as I mentioned earlier, we have now incorporated district safety committees into Article 14 of the agreement. And the other 2 are Article 15, Dispute Resolution Process, Article 15, Dispute Resolution Procedure Task Force. Those 2 MOUs are being deleted because they have been combined into the Dispute Resolution Process MOU. The language is substantively the same. It's just all been combined into one long document, kind of rearranged in an order that we think makes more sense. Every other MOU we've either talked about in the modifications, if it was substantive, or they're being continued or being continued with something as minor as date changes. Next, we have the questions and answers. A lot of you sent in questions, and we very much appreciate you doing that. Some of the questions are on similar topics. A lot of the questions are things that probably were sent in early on that I've already covered. But we'll go through and try to answer each of them and just be sure that at least the topics of all the questions have been covered. So question number one, why was the fixed office time reduced from 33 minutes to 20 minutes? And does this change the M39? Um, Let me answer the second part of the question first. No, this does not change the M39. The new MOU on fixed office time, it's right there in the title. It's fixed office time in a joint route adjustment environment. And it's not a reduction in the amount of fixed office time. What this MOU is a commitment to develop a new way to evaluate it. It describes what that new way will include, which is figuring out a way to evaluate it for each assignment, and then sets bare minimums for each line item. Now, if you compare those line items, as I described earlier, to the minimums that are in Chapter 2, the minimums that have been used for those line items in previous joint processes, the most significant difference in one of them is in line 14. But what is this agreement sets these baselines. It does not set the total minimum fixed office time. It only covers what each of those line items would entail in a joint environment going forward. And of course, in any negotiation for a future joint route adjustment process, what that office time methodology would look like would be part of the negotiations and done consistently with that MOU. Okay, next, other unions got massive pay raises. Why did we only get 1.3%? So first is in this tentative agreement, we do not only get 1.3%. 1.3% each of the 3 years is the baseline general wage increase, but as we talked about in detail in the beginning, that's only one piece of the puzzle here. So you've got the COLAs, you've got the changes to the wage structure. We went, I think in great detail of all the things that are considered and negotiated in Article 9. As far as the comparisons to other unions, it's a very natural thing to do. Certainly it's something that we are interested in and pay attention to, standing in solidarity with our brothers and sisters. We've done that for a long time, not just over the last couple of years. Thankfully, over the last couple of years, we've seen a lot of our sister unions in other industries and in industries more similar to ours have a lot of success in the private sector in bargaining. I would say that there are pieces that are certainly comparable, and we absolutely utilize that in our bargaining process. We utilize that, should we have ended up in interest arbitration, particularly comparability and the standard that's in the law, as you've heard about early on. But I will say structurally, our collective bargaining agreement, this tentative agreement, as well as previous agreements, are different than what we see in a lot of the private sector. You also have to, for context, I think, look historically. We have zero concessions economically in this agreement. Nothing. There's not one thing. Everything is an increase. There's no change in anything that cost us money. Our health insurance remains exactly the same in terms of the percentage that we pay. All the pay increases are pay increases are completely rolled in, to our agreements. And if you look over, let's say, the last 10, 15 years, a lot of the unions that we see in the private sector having success now, they're having success because through difficult bargaining periods for them, frankly, their struggles and difficulty were greater than ours. I mean, we see a lot of unions achieve, significant increases in terms of what they call their general increases, but they don't have cost of living protections. Therefore, through this period of inflation, they've not got near the pay increases that we've had. There are, generally speaking, in the private sector, much more concessionary things that happen in terms of the nature of a bargain between employer and the union. And then, the dynamic of work rules and the protections that we have are so extensive that we've bargained over time is also very different than what you see in the private sector. So in some ways it's comparable. It certainly is better than a circumstance that we've experienced in the past where, unions were not having much success. But at the same time, I think that it really comes down to the structure of our agreement, the way the COLA formula has served us, maintaining that. And I think if you compare really to any union over the last decade plus, in this era of bargaining since the recession, which had, obviously affected us, but affected a lot of other industries as well. Our union has done really, really well. And as we talked about earlier, this agreement represents, even more economic benefit than the previous two. Another piece that's just worth mentioning here is the we've talked about the financial condition of the employer and how that plays into interest arbitration. Well, that's 100% a factor in the private sector too, with our sister unions. And when their employers are doing well financially, they have success. And the fact is that we see these large private sector employers currently are in many cases making billions of dollars in profits, and that creates a very different scenario than what we currently have with the postal service. That in years past it has been very different. I mean, we all would probably remember the auto restructure, just for one example, but that was true of a lot of industries that really have had different periods of struggle over time. So it's very important, I think, to look at it with the appropriate context. And we would put our union's history in collective bargaining up against any union's history in collective bargaining. And I certainly believe that this agreement continues under fairly challenging circumstances. The structure and the way we have bargained in the past, it has served us really, really well, and will continue to serve us in the future. Okay, next is a question about 12-hour limitations. Is someone who volunteers to work beyond 12 hours guaranteed to work those hours prior to a non-ODL being forced to work? So essentially, this question is, just to rephrase it a different way, does the Postal Service's obligation under Article 8, Section 5G change? So the fact that a non-ODL can volunteer, if they volunteer to work beyond 12 or 60, is the Postal Service obligated to work them whatever they volunteer prior to working a non-ODL? And the answer to that question is no, they are not. There is no change to their obligation. Their obligation remains to work them up to 12 and 60 under 8.5G. The fact that they now will have the ability to volunteer and go home when they reach those maximum work hours and have protection does not change their obligation. So their obligation is the same there, as well as in the provisions of the letter carrier paragraph as well. Next one. What happens if the contract is not ratified? What happens next? What's the timeline? Do we start over, or is the TA the bare minimum that we can get? Good question. I've mentioned that we should have the ratification results of the balloting sometime in mid-January. If the agreement is not ratified pursuant to Article 16 of our Constitution, I would go back to the Postal Service, obviously attempt to negotiate more within 15 days. It's a time frame that Article 16 of our Constitution includes. If we are unable to reach agreement at that point, then we would proceed to interest arbitration, which we are prepared to we're prepared to do. As far as the timeline for interest arbitration, that would depend on availability of a lot of people, starting with the arbitrator that we had chosen, arbitrator Dennis Nolan. So in the event the agreement's not ratified, the reality is the likelihood of us coming to agreement with the Postal Service on something else within 15 days is probably not great. So we would likely immediately reach out and begin that scheduling process. Honestly, we would probably be looking at spring or summer in the event that happens for hearings. We would need, probably weeks of hearings, and then it's almost impossible to predict like exactly when an award would be issued. But it's probably fair to say that we would be talking about sometime late in 2025 at the earliest. As far as the question about do we start with the TA, is that a minimum that we could achieve? No. When we go to interest arbitration, what's in this TA is not relevant at all. What we would do is probably sit down with the Postal Service as we've done in previous rounds of interest arbitration, and certain things I'm sure we could agree on that we would include in the agreement, but the economic issues would be in dispute. Each side would present their proposals, and then the process would play out. So you certainly do not start with the tentative agreement. You start at zero, and each side is free to propose what they want to propose and put on their case, and then the arbitrator would issue an award. Next question: are CCAs and PTFs guaranteed days off, and the weekly schedule subject to change? I think what you're asking here is, are the days that they're scheduled off subject to change? So the language in Article 8 requires that they be scheduled a day off, and that's the Wednesday of the week before. Is it subject to change? Yes, of course. Scheduling for CCAs and PTFs is always subject to change, but the guarantee for the day off remains. If, of course, someone is on a hold down, then the ability of the Postal Service to change that day off is exceptionally limited in that case. In fact, they almost have no ability to do it. If they're working on Sunday, which obviously comes into play depending on parcel delivery that happens that day. So the short answer to the question is yes, it is subject to change. But what's not subject to change is the guarantee that they're still guaranteed that day. Oh, it looks like letter carriers at the beginning of the pay scale and at the top step got all the raises. What about letter carriers in steps C through O? Yeah, so we talked about this in detail earlier on when I was talking about the economic provisions. And I think that really the chart I covered that shows the pay increases demonstrates that it's done in as fair a way as we could do it, starting with step P and then gradually increasing all the way back to the beginning steps. And in fact, the people at step C through O, they're those in the middle of table 2, the amount of increase they get when you factor in everything in Article 9 that we bargain from a dollar standpoint is more than those at the beginning or the end of the pay table. So, we were able to maintain that in a very fair way while also, meeting our goals of increasing the starting pay and then increasing the top pay, which benefits everyone once they get there. Next is, why did it take so long to get this contract? Why couldn't we get this agreement a year ago? Because we in the Post Service were not in agreement. That's really what it comes down to. If we could have reached this agreement a year ago, there's a strong possibility that, we would have had this agreement at that point in time, but we just simply did not. You go through a lot of different possibilities in bargaining and, from both sides of the table. And, thankfully that over this extended period of time, for the reasons we talked about earlier, and this process, the Postal Service became more willing as we moved through to, spend the amount of money it would take to, for us to achieve the economic benefits that we achieve, which is, again, significantly more than we have in the last couple of rounds of bargaining, which translates to significantly more cost for the Postal Service, which is their concern. The idea of understanding what the other side of the table is thinking is always important in any negotiation. Okay, next, why did we agree to the 2 additional ODL lists? Because that's an official bargaining position of the NALC. Resolutions to create the exact list that we created had been submitted and adopted by the delegates of our convention. Another overtime one: can people on the work assignment list also sign the non-scheduled day overtime desired list? No, there is no change to the work assignment list at all.
Would you start again on that?
Yeah.
Somebody's back here.
Yeah. Can people on the work assignment list also sign the non-scheduled day overtime desired list? No, there is no change, as I mentioned earlier, to the work assignment list. So if you're on the work assignment list, you're on the work assignment list. You can't. There's no change in that regard. What kept us at the bargaining table so long instead of going to interest arbitration last year? Because and we've talked about a lot of this already, but we continued to believe we could achieve through negotiation a better result than we could achieve through interest arbitration when you consider all the circumstances, without taking on the inherent risk, no matter how big or small it may be, that comes with interest arbitration. And I think it's important to point out that I oftentimes in conversations, and I get questions, I think there's sometimes a very romanticized view of what interest arbitration is. Um, many of our members have been in arbitration hearings at the regional level, which are conducted professionally, but are often very adversarial in nature. Um, Interest arbitration is a very different process than that. It is, conducted in a lot of ways like a very boring legal um, procedure. It's there's a lot of legal argument involved, and it's just by its nature a very conservative process. And ultimately, that neutral arbitrator makes a decision. And what history told us, as you heard from Jim Sauber earlier, is the results are usually neither side gets everything that they want in interest arbitration, and there's also, of course, risks that come along with it. And our history tells us that the circumstances around bargaining, many of which Postal Service often presents in their case to counter what we present, have there's been some consistency in terms of the results. So, ultimately, the continuing to make progress and get closer to an agreement was the decision that was made, and that decision was made because we thought it would result in the best outcome we could achieve without taking on the risks that come with interest arbitration. And that's exactly what I believe that this TA represents. Our competition can get good raises. Why can't we? Well, I would, number one, disagree with the fact that the idea that we can't get good raises. I think our union's bargaining history is really second to none. That we've talked a lot about the structure of our agreements and how that served us well, and it's really served us well over the last few years. I mean, letter carrier pay has gone up significantly, probably as much or more than any industry. And as we talked about a minute ago, I would just caution the differences in structures, the differences in bargaining environments, the differences in the way things are reported. Often you have other unions that may achieve a percentage increase that has a big number on it, but that could be a union that's had no COLA protection, and therefore, while we've gotten 25% in increases over the last few years, they may have gotten almost nothing. So every circumstance is very much different. But since the word competition was mentioned here, I think we should cover this a little bit. Jim talked about this some, I believe. But the comparability standard that's in the 1970 law, where our wages are in the career service should be comparable to those that do similar work in the private sector. to us, the argument we've always made and made successfully for the most part is that point of comparison should be the private shippers that are unionized, which is one large one. But there's always an argument there that there's a lot of other delivery folks that are out there these days, and so it's not always a given. If you look at this comparability standard historically, the relationship between the compensation that we have and the compensation, that our brothers and sisters with the Teamsters have achieved is stayed very much consistent. It ebbs and flows based on the timing of agreements, and with the agreement that they bargained last year, which was certainly a victory. If you look at that top pay in particular, which has mainly been the point that in interest arbitration we discuss what we project our top pay to be, it maintains the same historical relationship, and it's very much right in line with that comparability standard. So, okay, next, could we end up with less if we go to arbitration? Yes, we could end up with less. We could end up with less overall. We could end up with sort of a similar economic package overall that is divided up differently. Maybe not as at least in what we believe is fair, as I've described in detail. Of course, we could end up with short-term, attractive short-term things that don't have good long-term benefit, which is very much the opposite approach of that what our union's taken. It's one of the reasons that our COLA has always been so important, and bargaining, maintaining that and the way it served us over the years. Just to throw out one possibility, lump sum payments as opposed to including things in the COLA formula or in a, really a bad scenario. There's always a possibility of modifying the COLA formula and giving a larger increase over here that long term is going to result in our people making a lot less money. So, all those possibilities are on the table. The short answer to the question, could we end up with less? Yeah, we absolutely could. And obviously, as we've explained in detail, I don't have any expectation that we would end up with more. So we could definitely end up with less. Monetization of annual leave. Why is a question on that MOU? Why is the less than 75 hours of sick leave language in there? That's a product of negotiation. There are other postal employees, some represented by unions, some that are managers that have the option to monetize annual leave currently. That's the requirement they have. So, Post Service, of course, was, not interested in creating different requirements for us. But the short answer is, obviously our preference would be to not have to have the maximum carryover and not have, a minimum sick leave requirement. You could sell back whatever you wanted, but that's the nature of negotiation. You don't, always get everything you want. So, but it is consistent with the requirement that other postal employees have. Last one, I think, is why do we care about the Postal Service's finances? Let me answer that in two parts. Number one, we care about it in bargaining, certainly, but well beyond bargaining, because that's where we work, and our job security and long term is very much dependent on a successful, financially stable postal service, and we've been heavily involved in that fight for a long time now through policy changes that needed to happen legislatively, policy changes that still need to happen. Working with them because job security is one thing, and then the collective bargaining environment. A healthy postal service financially is, history tells us, over the last 54 years, it's much better for us in bargaining. I will make this point though, that the postal service's financial state at any particular point in time does not impact our priorities in bargaining. It does not impact the things that we try to achieve in bargaining, but it is a consideration in making decisions of do you finish an agreement or do you go to interest arbitration? Because as Jim explained earlier, that's an issue that comes up in interest arbitration. So it has an impact, but it has an impact because that's reality. It doesn't have an impact because it's the NALC's priority. It doesn't impact what we attempt to achieve, but it is just a fact of life. And just like I've talked a little bit about our brothers and sisters in the private sector that have had some success in bargaining. The financial conditions of their employers impact their bargaining in a positive way sometimes and in a negative way sometimes. So, really reemphasizes the need and hopefully provides an understanding, for those that may not be as familiar as to why we are so engaged on Capitol Hill. We're so engaged in elections. We're so engaged with the White House to try to ensure that we get changes made that puts the Postal Service in a positive financial position going forward, because that's where we work and we want them to succeed because that's what's best for us, but also because of the impact that it has on our collective bargaining environment. Thank you for joining and watching or listening, whatever you may be doing, to this virtual wrap session. The intent of this is to educate you and give you information so that during this ratification process, you can make your own decision. But I think it's very important that you, as an NALC member, understand the totality of the agreement, the context, and that's really what I tried to do here is give you that information and answer the questions that were sent in. Ballots for this ratification process are in the mail. If you haven't received yours, you will receive it very shortly if you're an eligible voter. And I encourage you to take advantage of your right, participate in one thing that our union is very proud of is that we are the most democratic, little d, democratic union in this country. All of our active members have an opportunity to vote. I want to take this opportunity to also thank the officers and staff at NALC headquarters that did a lot of hard work for a long time over this round of bargaining, both in preparation as well as the bargaining process itself, and even since the tentative agreement to get the information out there. It takes a lot of people to make this happen, and they've done an excellent job. And now it's up to you, the members, to decide. So thanks once again for joining. We appreciate everything that you do for our union and what you do to serve the people of this country. Thanks.